My name is Jenna Miller. I work at the 17th Judicial District, and I am our Assistant Victim Witness Coordinator. A victim witness coordinator is basically your main point of contact as a victim within the judicial system. They help keep you up to date on what's going on. They can answer certain questions for you related to basically anything that you need to know, how the court process works, what's going on with your case. We also help prep trials, keep witnesses in the loop, get them subpoenaed. We do a lot of criminal injuries compensation as well. And if you haven't been contacted by a victim witness coordinator in your office, just reach out to the DA's office and they'll be happy to answer any of your questions. We try to get to as many people as we can. I'm the only person that goes to court. It's just me in 4 separate counties. So it's a lot. And in the bigger counties, they have more victim witness coordinators, but it's not a reality that we can get to everybody. We normally focus on the big personal injury cases, especially cases that are going to go to circuit court, so a lot of the felonies. But if we can reach out, or if you need help, just contact the DA's office, because we're there for you even if we're not reaching out. So the DA, otherwise known as the district attorney, they are the chief prosecutor for each judicial district. And that's mainly who you'll be dealing with. They handle every case in the state. There is one for each of the 31 different districts. And then as of August 2022, the state legislature has added an additional district. So there'll actually be 32 within the state. Within the district attorney's office, there are ADAs, or assistant district attorneys, and that's mainly who you'll be dealing with as a victim in the case. They're situated in general sessions court and in circuit court, and so they represent the state in prosecuting all of the cases. The first thing that happens is always that they are allowed to have bond. Unless it's a capital offense, then they're not allowed to, but it's a constitutional right of an offender to have a bond set. If they can post bail or make bond, they're still required to show up to every court proceeding. That's their surety to the court that they are going to. And once that happens, there'll be that initial appearance, and it will either be in front of a general sessions judge, a magistrate, and they'll make sure that they have an attorney appointed to them, because that's another constitutional right of an offender, is to have legal representation. They can also decline it and do what's called pro se and just proceed representing themselves, basically. But you make sure you have an attorney, and then you just start through the legal process through general sessions, which is multiple court cases. You'll either have a preliminary hearing or you can waive that, and then if they're felony charges, you'll go up to circuit court. If you go through a bonding company, they normally require 10% down. So whatever your bond is, it's 10%. But it's basically up to the bonding company if they really want to have that surety against you, because if you skip, they're out all of that money, not just the 10% that was put down. Whenever they look at setting the bond amount, they kind of look at 3 certain things. What was the seriousness of the offense? The level to keep the community safe, and then what's the flight risk of the offender? Are they known to the community? Do they have ties? If not, the judge may really not grant bond, or they'll set a very high bond just to assure that they will come back. If you're in general sessions, it's not that you come up there and they say, do you plead guilty or not guilty? That's normally in circuit court. And your attorney kind of does that for you, that when they get the indictments back from the grand jury, your attorney will say, Your Honor, we plead not guilty to these charges. We'd ask the case to be passed to get discovery. But in general sessions, once a resolution has been reached, then they can plead guilty at that time. But normally at arraignment, it's just to make sure that they have representation if they want it. And then the case is normally passed to allow the defendant and the attorney to keep talking and let them kind of know their side of what happened. A lot of the time they just kind of want to know what to expect. They all watch true crime TV or Law and Order, and it's not how it really is in real life. So it's a lengthy process, and there's going to be multiple continuances. I always tell my victims, look, you're going to get upset at us because it's going to take a while. But mainly they just want to know the same type of things. You know, how can I keep myself safe? What can I do? Do I need to do anything? Are you going to keep me up to date? What are they looking at? You know, just the same types of questions, but it just is always different with somebody else. If they've been within the system, they kind of understand. But if not, it's very confusing for people that have never been in the system whatsoever. A lot of times you can either contact our office, we can find out from the jail, but the easiest way to do it is through what's called VineLink. It's an online website, and there's a mobile app as well, and you can just go on there. Almost all of the states have it now, and you can just go on there and type in their name. You can get registered for it, and they will tell you as soon as they are released, you will either get an email, a phone call, a text, whatever you choose as your means of communication with them. You can go to the Tennessee Voices for Victims website, and that is www.tnvoicesforvictims.org, and that will give you all the information you need to get registered or to find out more about VineLink. With a transfer, that can mean so many things. A lot of times when you hear transfer, it's say there was charges in one county, but the arrest happened in another. Then that offender is going to be transferred back to where those charges initially occurred. Just because they were arrested in a different place, unless there's charges there, they normally send them back to the county where that originated. They'll also be transferred if there's any safety reasons for the jail or for the offender themselves. A lot of times, if the offender has severe health needs or mental health issues, they can send them to TDOC to protect themselves and to protect the jail and the other inmates inside. If you're signed up for VineLink, you won't ever get notifications if they're just taken to a different court and then brought back. The only time you'll really get that notification, and it will say release, but it doesn't mean they're released. Normally when it shows release, the victims will call me and say, what's going on? I just got a notification they're released. But most of the time what it means is they've been just transferred to another jail. So they've been released from one jail and gone to another. A lot of times I just kind of get them prepared. It's going to happen, unfortunately. We can't keep them inside even if we would love to, unless it's, you know, one of the huge cases where life is determined. But you know, just to keep an eye out if they need anything. I always keep open lines of communication, even far after my cases are finished with us.